Hello everyone, and welcome to this evening's session. Tonight we will be discussing the 1999 Cherokee Constitutional Convention with special guest Mr. Jay Hanna and our host Dr. Julia Coates. I'm your moderator, Kimberly Gilliland. We would like to thank all of the Cherokee Pens Project volunteers that have graciously agreed to participate this evening and Star University's Department of Tribal Governance and Administration. Star University is an international university that will be launching degree programs and certificate programs in the fall of 2018, utilizing virtual classrooms and 21st century technology, truly bringing the classroom to students. This fall, Star will partner with the Cherokee Pens Project to offer a certificate in Cherokee Government and Society, as well as Cherokee Language certificate programs. For more information, please contact Star at info@staruniversity.org or visit the website at staruniversity.org. At this time, I'd like to introduce today's presenters. Julia Coates is a citizen of the Cherokee Nation. Born in Pryor, Oklahoma, and raised in Northern California, she holds BAs in Anthropology and English from San Francisco State University and a PhD in American Studies from the University of New Mexico. Dr. Coates was a delegate at the Cherokee Nation Constitutional Convention, was the project director for the award-winning Cherokee Nation History course, and served 2 terms on the Cherokee Nation Tribal Council. Our special guest tonight is Mr. Jay Hanna. Mr. Hanna is a Cherokee Nation citizen and holds a Bachelor's of Education degree from Northeastern State University. He attended the Harvard University Kennedy School of Government, focusing on Native American government reform, and has a Master's in Communication and Management from Oklahoma State University. He was the chairman of the board for the Cherokee Nation businesses from 2007 to 2012, and is currently the executive vice president for financial services for Bank First. Mr. Jay Hanna was the chairman of the 1999 Constitutional Convention. His experience and historical context is so extensive surrounding the Constitutional Convention, I will now hand over the floor to him. Welcome, Jay.
A pleasure to join you all this evening. My grandparents would be upset with me if I did not say Oseo Nagaga. It is good to see you all. Didagongi, Adair County. I am from Adair County. Descended from the Stars, the Adairs, the Stills, the Binge family of the Cherokee Nation. And it's my pleasure tonight to speak with you in a very broad perspective on the 1999 Constitution. Now, I know that Dr. Coates has done an outstanding job of leading these sessions and looking at the other organic documents of the Cherokee people from 1827, 1839, and all the way to the 20th century with the creation of the 1975 Constitution, sometimes referred to as the 1976 Constitution, depending upon which set of Cherokees you're talking to and whether they are discussing its actual writing or its adoption. But we will take just a brief moment or two to ramp toward the 1999 Constitution by touching base with those earlier organic documents of the Cherokee people. Specifically, I would look at the 1839 Constitution, the very document that helped bind the Cherokee Nation after its fracturing from the time of the old settlers' removal west of the Mississippi and ultimately into what we know as northeastern Oklahoma. And then those that traveled on the Junilosi, the trail where they cried, led by our principal chief, John Ross. It was there in September of 1839 that the rejoining of these fractured elements of the Cherokee Nation put a very firm foundation stone in the creation of that constitutional document, and it bore us well on through the American Civil War, through Reconstruction, and during the diminishment of the Cherokee Nation through allotment, and ultimately during that period of time where the Cherokee Nation sort of slipped into a Brigadoon moment, where our government was not eradicated, but it may have been diminished and it slept for a while. Through those following years, and I know Julie has talked with you about the diminishment of our court system and the 1906 Act and our inability to elect our own principal chiefs and leaders, not until the Principal Chiefs Act of 1970. And some 17 principal chiefs were appointed by the President of the United States. I often have friends that ask, well why? Well, the Cherokee Nation still owned many, many assets, and at least the federal government, in their diminishment of the tribe, saw to it that when they were transferring property, that they did so properly by seeing to it that an official of the Cherokee Nation executed those documents. We're very proud in our family that one of my great-great-uncles, W.W. Hastings, who was appointed principal chief by President Roosevelt for one day in around 1936, his entire responsibility under that appointment was to transfer the piece of property that would be removed from Cherokee Nation ownership to the United States government to create the site for the Indian Hospital, a hospital that still bears his name today. But his appointment as principal chief was from sun up until sundown. Those years where appointed principal chiefs moved in and out of positions of authority were clouded years constitutionally for us. I mentioned earlier to Dr. Coates that I have a copy of the Constitution of duly enrolled Cherokees by blood in Oklahoma in Tahlequah in 1948. These are transcripts taken by my great-great-aunt L.D. Starr, who was on the executive committee of this convention. It lasted for about 3 days. It was in Tahlequah. It was on the campus of Northeastern State. And you read through it, and there's a wide variety of names that modern-day Cherokees would recognize, aside from the principal chief appointed under the Roosevelt administration, Chief Milam, but also a young leader of a group of Texas Cherokees by the name of W.W. Keeler was there at that convention. There were members of the Katua Band. There were those recognized of the clan structures of the Cherokee Nation, and a full list of delegates as well, and a very detailed set of information in their discussions, primarily not so much as a constitutional convention, but as a recourse against the United States in reclaiming monies owed to the Cherokee Nation, but they had to do so in this fragmented structure of Cherokees from Texas, and old settlers, and Katuas, and the Cherokee Nation that was still under its 1839 Constitution. But Julia has told you that under and after the Principal Chiefs Act of 1970, yes, the federal government, much as they did during the 1930s, feeling very badly about what they had done to diminish tribal governments through the Indian Reorganization Act of 1934, as well as the Oklahoma Indian Welfare Act of 1936. The Principal Chiefs Act of 1970 allowed us to begin the process of rebuilding our government. W.W. Keeler, handing the reins to Chief Ross Swimmer, saw the need for a modernization of our Constitution. And thus, this document made its way into a replacement of the 1839 Constitution. I have no doubt that the framers of this document had no idea. They could not see over the curvature of time to a moment when Cherokee Nation would once again have its own marshal service, when we would be able to effect arrest against citizens or non-citizens within our bounds, and prosecution within our courts would exist. The Oklahoma or the Indian Child Welfare Act did not exist at that time. The fact that tribal government could arrive in courts and they could, in fact, legally direct the placement of Indian children. All of these things were well beyond the horizon of the framers of the 76 Constitution. But one place that they, in fact, were profoundly visionary is to be found in Article 15, where they talk about the supersession of the 1839 Constitution and prior article that looks specifically at initiative, referendum, and amendment of the Constitution. This is Article 15. They're in Section 9, and I'll read just a portion of it because I think it sets our discussion tonight most appropriately. No convention shall be called by the council to propose a new constitution unless the laws providing for such convention shall first be approved by the people on a referendum vote at a regular or special election. Any amendments, alterations, revisions, or new constitution proposed by such convention shall be submitted to the electors of the Cherokee Nation at a general or special election and be approved by a majority of the electors voting thereon. Before the same shall become effective, the question of such proposed constitution shall be submitted to the members of the Cherokee Nation at least once every 20 years. Well, perhaps they realized in 1975 that they could not see beyond the curvature of time, and that Cherokees in the future would perhaps struggle under a document that was limited in its distance vision. So, 1995, as required by the Constitution, it went on the ballot. I remember the election. I voted for it. And apparently several other Cherokees did the same. And so in 1995, the resolution asking for a new constitution to be considered was passed. Now, when we look at the political environment of the Cherokee Nation at that time, it was a very tumultuous period. Dr. Coates has written extensively on the constitutional crisis, the troubled years that were going on between 1995 and even into the year 2000. But during the latter 90s, there was a bit of a political crisis. I'm not an expert on all of the political ramblings there. I'm simply a citizen of the Cherokee Nation, and probably, like many citizens, did not pay much attention to the political wranglings that were going on at our council house. But make no mistake about it, it was a tumultuous period of time. So consequently, between 1995, with the people's choice that we should in fact be revisiting the Constitution, not a thing happened in 1995, 1996, or 1997, not until the spring of 1998. Troy Wayne Poteet, who was on the the Tribal Council, and was chair of the Rules Committee, took it upon himself to see to it that that mandate from the people would be manifest in a set of behaviors, at least from the Tribal Council, that would lead us toward consideration of Constitutional Convention. It was a fascinating process of watching the discussion of, well, how do we go about this? They finally seized upon the creation of a Constitutional Convention Commission. It was to have 7 total members. There would be 2 citizens appointed by each branch of our tribal government. So 2 from the executive branch, the chief's office, 2 from the Tribal Council, and 2 from the judiciary, which under the 76 Constitution was actually a limited 3-person tribunal. One of the great transitions between the 1839 Constitution and the 75 Constitution was the fact that the Cherokee Nation was much smaller in the 1970s. And so the need for a bicameral house and the need for an upper and lower court system simply was not in place during the 70s. So the tribunal was requested to submit 2 individuals. Those 6 commissioners would then appoint a 7th. I was asked by the Tribal Council to serve as a delegate to the Constitution Convention Commission in the spring of 1998. What's fascinating is that the Tribal Council passed no governing legislation for that commission. They actually extended the responsibility to the commission. You tell us how you should be about the process of operating the taking up of the question of how to prepare a constitution for the Cherokee people. that was when things began to really take a turn. There was great discussion among our council at our seating in August of 1998. As a matter of fact, one of the commissioners resigned in our first meeting. There was such a political environment that we didn't even meet inside of the headquarters of the Cherokee Nation. We met at Sequoia Indian School. We were attempting to distance ourselves from the political environment and take on the trappings of true citizenry independence. We moved to draft an enabling legislation that would outline the scope of our work. And the thing that perhaps created much dialogue among the tribal council is that we were insisting upon independence, that it should be an independent commission, not reporting to the principal chief, not reporting to the tribal council, but in fact doing what even delegates of constitutional conventions should do. That is to be beholden only to the citizenry that Constitution serves and to the Almighty. Well, there was much debate, much back and forth that went on at the council house. We did propose the fact that there would be a sunset clause in our enabling legislation. I described it as a window will open and a window will close. And so there should be no political concern that there's an independent commission of a federally recognized Indian tribe that somehow is birthed and just continues in perpetuity. We will have a very specific set of responsibilities and a time frame that will be limited by our scope of work, and it will close. Tribal Council approved it, gave us a budget, and we set about the work of looking at what to do next. One would think historically that a tribal government that has had a written constitution since 1827 and statute structure of law that goes to the very earliest of the 1800s, that we would somehow, as a civilized tribe, as thinking people, that we would have left a recipe book with all these constitutions for how constitutions are generated. We found lots of historical information on 1827, who was there, how delegates were selected back in the original nation. We saw the consternation in the tribal crisis of 1839. The 48 Constitution, like I say, it had a very narrow agenda item. In the 75 Constitution, we actually sought out delegates. Not only was Principal Chief Ross Swimmer still very much interested in our work, and we spoke with him a great deal, but we sought out delegates to ask what the process was like in 1975. What we found is that ostensibly Chief Swimmer sort of hand wrote that Constitution. There were a variety of community meetings. They didn't really have a convention. There were not delegates, so to speak. There were community representatives. They provided input to the principal chief, but it was not a true convention as one would have imagined. We looked at other tribal constitutions. We were students. We met every week, not away from the council house. We met on the campus of Northeastern State University, the Ageo Junta Schools de Juntana, the place where the big girls learn, since we Cherokees may have created the male and female seminaries in 1846, but we failed to realize we didn't have a word for seminary, so we just referred to it as the place where the big girls learn. We met there in Seminary Hall, in the second seminary building, opened in 1889, and we met there every Saturday from August through September and October and November. In parallel to our studies of looking at other tribes' constitutions, at looking at our own historical records, we also set about a part of asking our own citizenry, what do you desire to have taken up in our Constitution? And so we set out to have 20 plus public hearings throughout the 14 counties that make up the Cherokee Nation's historic boundaries, as well as Cherokee population centers across the United States. As we know from Chief Wilma Mankiller's story, the ultimate of diminishment of the Cherokee Nation during the 20th century was almost a second Trail of Tears, where many of our tribal citizens were removed to California, allegedly for employment or for a better life. One might speculate, and I'm only an individual, but one might speculate that it may well have been yet the final solution for the diminishment of the Cherokee government, cause its citizens to be separated. But I guess the federal government and other entities, whether they were well-meaning or whether they were maniacal in their plan, did not anticipate that wherever Cherokees are, they're going to come together. And so there were large Cherokee communities, tribal towns as I call them, in Sacramento, California, in Los Angeles, in Albuquerque, New Mexico, in Portland, Oregon, near Hood Mountain, in Seattle. Across the United States, we looked for these population centers of tribal communities and went to those communities and held public hearings. We invited Cherokee citizens to come and tell us what they thought of our governmental structure, of their dreams and desires, of topics that we should take up. And to make certain that no one would have selective memory, we took court reporters to each one of those meetings and transcribed every word spoken. Our very first one was held in Tahlequah. The very first Cherokee citizen to give testimony in a public hearing was Martha Berry of Tyler, Texas. She drove all the way from Tyler, and just by luck of draw was selected as the first citizen to give testimony on the constitutional structure, what she believed that we should be taking up. By December of 1998, we had a wealth of information. And it was not from scholars. It was not from looking at historical constitutional efforts. It was not from our tribal government. It was from citizens of the Cherokee Nation. Many who had been following the constitutional crisis, many who were just forward thinkers, many who were looking at the Cherokee Nation of 1975 and 1998, and perhaps looking over the curvature of time to 2018 or 2020. We actually had enough information collected that we began to put trending documents together for topics, and it was amazing. Cherokees in Houston, Texas were thinking about the same things that Cherokees in Los Angeles were thinking about. Cherokees in Los Angeles were thinking about what Cherokees in Kansas were thinking about. So these 21 public hearings with all this information, it became painfully obvious to the commission that our role would be much more expansive than we had planned. It was actually almost humorously talked about among the commissioners in September of 98 that, well, we'll have a few ideas and we'll recommend some changes. There'll be amendments to the 75 Constitution. It was painfully obvious by December of that year that there were so many elements that our citizens desired to see embedded in our organic document that the only way for us to inculcate those would be to write an entirely new constitution. Well, this is where naivete takes center stage. The commissioners, not because we were being presumptuous, we simply moved about the concept of, well, we'll take all these ideas, we'll put it into a draft constitution. We began to talk about, well, if we were to have a convention, how would we populate it? I recall at a public hearing, after each of our public hearings, we'd have planning sessions. Oftentimes these meetings would go on for days. We talked about, well, if we were to bring together a group of delegates, how would those in fact be selected? So we moved about a process that says we should go back to the three branches of government. We should have each of the three to appoint 8 delegates. We should look at all of the citizens that gave testimony across all of these public hearings, and we as a commission should select 24 delegates that were perhaps the most articulate, those that were most impassioned, those that had the greatest breadth of suggestions of topic. There was great discussion, though, about the political environment, even in the fall of '98. There was great concerns that if we were to have a constitutional convention, that either, and I apologize for using names, but it's just historically accurate. Chief Byrd was our principal chief, and there was sort of two concentric circles in the Cherokee Nation, those that were favorable to the Byrd administrations and those that were not. And both sides looked for a way to either besmirch the process of having a convention, fearful that their political opponents would somehow take over that convention and structure an organic document that would be repugnant to them. And while there would be few things written on my headstone, I think it may be the fact that I advanced the idea that 24 of the delegates would be selected at lot. I joked in prior critics that after all, we're in the tribal gaming business, so if we're willing to trust our financial future to bingo, maybe we should just pull out delegates from a hat. So we widely published the fact that any Cherokee citizen that had an interest in participating in a constitutional convention and was willing to do so, they could mail in their name. And all those were put in a large box, and this very hand rolled up its sleeve in front of the press. We were always very open about all of our discussions, and we invited the press to come in and watch, and we pulled out 24 pieces of paper that had the names of Cherokee citizens. And so with 24, 24, 24, and 7 commissioners serving as well, we had 79 delegates. And we felt that they were evenly selected, representatives of the 3 branches of government, representatives of Cherokee citizens that were interested in seeing the nation move forward, Cherokee citizens that were drawn randomly at lot, proving that there would be not a majority from either of these concentric circles of political opposition that would somehow take over the convention. Naivete continued. While that may have been just a almost Forrest Gump level stroke of logic, we had to prepare for a convention, and selecting a time, a place, assembling all these delegates to travel, preparing stipends for housing, how would we feed them? And we were so naive as a commission that we thought we could do it just as they did it in 1948. We could do this in 3 days. The commissioners we put out an official call, and the delegates came to Tahlequah. We did not meet at the tribal complex, once again wanting to keep insulation between this very sacred process of writing our Constitution and the political mayhem that was oftentimes going on in our council house. So we met on the campus of Northeastern State University, the original Cherokee Female Seminary there in Tahlequah. The evening before that the convention was gavelled in, we invited 3 constitutional scholars, the chair of the law school from Arizona State University. There was a representative from the University of Kansas. We had a Harvard representative who came and talked with us about the importance of self-determination of Indian peoples and the uniqueness. I think it swept over the entire delegation, the uniqueness of what we were about to initiate. Apparently, the concept of a Indian tribe holding a constitutional convention was not found in evidence anywhere else in the United States. Most of the tribal governments here in Oklahoma, some 39 federally recognized Indian tribes, fall into about 3 basic categories. Or tribes that have reorganized their governments under the Indian Reorganization Act or under the Oklahoma Indian Welfare Act 1936, or as the Cherokees always have been, an inherent sovereignty tribe. That's always been worrisome, and keep that in mind as we go through this discussion, because the Bureau of Indian Affairs particularly had always found great concern over the fact that the Cherokee Nation was not organized under those federal framings for governmental structure created in the 1930s. So having a great discussion the evening before, and somewhat settling into our mind that we were about to launch on something that was historic, the commission went to bed that evening thinking all is in ready. We've been able to assemble all of our delegates. No fistfights have broken out. No gunfire has occurred. We're all here in a good place. We're feeling good about one another. And yes, the delegation was fascinating to look at. All colors, shapes, and sizes of Cherokees. There were full bloods. There were mixed bloods. There were thin bloods. There were people from the current administration camp. There were people that were opposing the administration. There were Cherokee citizens that were simply impassioned about their tribe's history, its heritage, and they were passionate about building an organic document that would serve not just the Cherokees of that day, but the Cherokees of the future. When is this happening? It's February of 1999. The next morning, on February the 26th of 1999, Constitutional Convention was seated, and members of the Cherokee Judicial Tribunal swore in the delegates. And this is where the Tribal Constitutional Convention Commission commissioners had once again just not thought about it deeply enough. Remember, we had taken all these great ideas and put it into proposed documentation, a proposed constitution. We had decided that we would serve as sort of the officers of the Constitutional Convention. Charlie Gord, Dr. Charlie Gord, who was appointed by the executive branch from the Byrd administration, had been named as chairman of the Constitutional Convention Commission, and he had planned to be the chairman of the convention. Once he gavelled the convention in to order, all of the plans of the commission flew out the window. A delegate very quickly stood and made a motion to nominate and to elect a chairman of the convention. It was an uneasy moment, but it was painfully obvious to me that the convention now belonged to the delegates who were there to serve the citizens of the Cherokee Nation. I was a bit shocked that I was nominated. So was Dr. Gord. We were asked to come to the front of the room and to explain our credentials. He was from tribal government, PhD. I'm a citizen of the Cherokee Nation from Mayberry County. Funniest thing that happened there that evening, I spoke of my family and my grandmother Gataya, Cherry Star, bringing us as members of the long-haired clan. As soon as I mentioned her name, there was a delegate that I heard and spoke loud enough on the front row. She leaned forward and she said, "He's Treaty Party." I kept thinking, my gosh, that's from the Boudinot assassinations of 1839 all the way through the 1840s. Surely we've gotten over that by now. I was elected chairman of the Constitutional Convention, and the gavel was placed in my hand. Now, there were a few things that the convention commission had distanced vision that actually worked in our behalf. Number one, we had advanced the thought that we would need rules of order. We selected Robert's Rules of Order. We also knew that, as I'm certain many of you in this class tonight, you have a working knowledge of Robert's Rules of Order, but we knew that a convention would require absolute fastidiousness with regard to procedure, because without procedure, this entire convention could devolve into a morass of disaster. We hired a parliamentarian, a fascinating lady. She was not tribal. As a matter of fact, she was held a PhD in chemistry and was a chemist at Phillips 66 in Bartlesville. And just some people go bass fishing, some people go golfing, she was a professional parliamentarian. I brought her to the stage and sat her at my left hand so that as we moved through our discussions and dialogue, that the mechanics of the rule of order would always have an expert seated immediately to our left on the stage to draw upon. And I had no idea that we were going to have to do just that. Remember, all of the plans of the commission are out the window. The delegates are now in charge of how the commission is going to proceed. It was decided that we would review the 1975-76 Constitution in seriatim process. So we were embracing technology. We were at the network building, commonly known as the NET building at Northeastern State University. Imagine a large room, 79 delegates, open to the public, open to the press. Television cameras from Tulsa, Oklahoma, reporters from Fort Smith, Arkansas, and from Oklahoma City, all coming. And I thought, waiting to see that moment of ignition when the Cherokee Nation would somehow spontaneously combust because of the constitutional crisis at the government level. They were there every day of the convention. And perhaps if there were any muckraking journalists there, they were sorely disappointed because the delegates conducted themselves. Some who would have, no doubt in a political discussion, would have devolved into a fist fight in the parking lot, conducted themselves with a great deal of decorum and respect for one another. And if nothing else, the chairman was willing to slam his gavel down so hard that the head would fly off of it to bring order to the room. Cherokee people cannot be creating their organic document in front of the world and acting as an uncivilized people. We have too much to hold up for our ancestors. We have too much to hold up for our future to do anything about. We moved through the 76 Constitution. It became painfully obvious that we were going to struggle. We also had a wide variety of technology base. We could draw. We had every treaty going back to the Treaty of Holston. We had our agreements in 1867 to adopt the Lenape or the Delawares, the 1869 treaty to adopt the Shawnees. We would know them as the Loyal Delawares and Loyal Shawnees. We had other important documents in the history of the Cherokee Nation to draw on for discussion purposes. During one of the recesses that we took, a young lady approached me as we were struggling with our technology, and she offered to help. I asked who she was. She was a young woman from Germany, and she was studying in Germany on government reform, and had flown to the United States to come to Telequid to watch a constitutional convention. Young Brigata also was phenomenally knowledgeable of the computer, and she offered to assist and sat, and her fingers moved at what would probably be, for those with a typing background, of about, 85 words a minute. I've never seen anything like it. We very quickly moved her into the position of being the scribe for the Constitution. Yes, we embraced the international assets of bringing a German to the Cherokee Nation to help us with our technology. So now we're armed for the remainder of the day, so being able to move and seriatim process through each one of the articles, each one of the sections, and we moved into a rhythm of debate and dialogue about those elements. We embraced through our rules of order that proposals that were made went on the screen. The language was then open for discussion. The chair would call for 2 speakers for, 2 against, limitation of 4 minutes. Time was kept. Debates would occur, oftentimes sticky issues. Recesses would be called, and caucuses would begin to evolve inside of the delegates. Someone from Los Angeles would resonate with a delegate from St. Louis, Missouri. They didn't know one another. They had not seen one another prior to this event, but because they had similar views and they saw the angle of the dialogue, that they came together to say, let's help to persuade these people that our position is best. The things that were discussed very quickly passed the 3-day limitation that the commission had envisioned. We started each day at 8:30 in the morning, and oftentimes would stay until the supper hour, and we would return to work, sometimes until 10 o'clock at night. It was exhausting. It was impassioned. There was a great deal of give and take and a great deal of debate that took place during those days that numbered 9 in the convention. When you look at the totality of what was being discussed, and I would be willing, Dr. Coates, to make available a copy of an article that I was fortunate to have published in the Arizona State University Law Journal. If you'd like to look at it online and search for it, it's volume 35, number 1, spring of 2003 in Arizona State University Law Journal, that talks about the Constitution. And here, I've kind of broken out the Constitution, and particularly those elements that we brought to the forefront of change between the 75 Constitution and the 1999 Constitution, as I often refer to it. Here, such things as, and I'll read from this article, the changes to the legislative article included creation of a speaker, a Galwaniski of the tribal council, and a deputy speaker. Prior to that, in the 75 Constitution, the speaker of the tribal council was the deputy principal chief. We thought that it was, I guess it's fine for the Vice President of the United States to technically be the chair of the United States Senate, but when you look at the Cherokee Nation, it did not make sense for someone from the executive branch to be chairing the legislative body in the tribal council house. We also, and this was brought much about by delegates from California, the concept of term limits were brought to the Cherokee Nation, long and hard in its debate. Now, take this as a moment of declaratory footnote. One of the other elements that the commission had envisioned that we engaged was not just the parliamentarian activity, but the fact that we took transcripts of the entire Constitutional Convention. A Cherokee citizen, or a court reporter from Stillwell, took up the contract and came. She thought it was just going to be 3 days worth of transcription. Why, it would be shorter than a divorce trial in Stillwell. After 9 days and 4,000 pages of testimony, I think she relooked at her contract. She never stepped away. There was no one substituted for her. She took down every word that was spoken at the Constitution Convention. She did so, not just because we engaged her to, but because we felt that years hence, that much of the legal discussion of the Constitution, as lawyers love to do, oftentimes they will want to debate the framers' intent. Oh, we know this from this particular document, but what was the framers' intent? There is no guessing of the framers' intent for 4,000 pages of testimony shows word for word, dialogue, debate, compromise, agreement. The framers' intent is there to see. Also in that document, aside from term limits, the power of removal, publication of laws, procedures for filing or filling vacated council seats, removal of the Bureau of Indian Affairs approval of Cherokee law, expansion of the tribal council by 2 seats. Under the 75 Constitution, we had 15 tribal councilors that represented citizens living within the historic boundaries of the Cherokee Nation, an area that makes up roughly 14 counties of northeastern Oklahoma. Through the years, the outward migration of Cherokees, in many ways, we have a sizable population of Cherokees that live in all those communities and states that I spoke of where we held public hearings. And they did so literally without representation. So 2 additional seats were brought into the council house. Many wanted more, some wanted less, but the delegates believed that 2, well, maybe it's much like the yarns of the creation of the word Calico, Dalagua, that 2's enough. So I still joke that those tribal counselors today, the at-large tribal counselors, they have the largest district in the Cherokee Nation because they represent Cherokees around the world and maybe even into another solar system. It went on to look at those 2 seats, the evoking of treaty rights that were allowed under 2 different treaties with the United States dating into the 1700s that provided for a non-voting member of Congress. They actually offered that to the Cherokee Nation. We've never, even to this day, sent anyone to Congress. I guess they would be seated next to the kind representative from Guam or American Samoa. And we later researched to see if these were treaty tokens that were handed out to tribes between a very young United States and tribes, and we found none. We believe that we are the only native government to actually have been granted non-voting delegates to U.S. Congress. There were changes in the executive article that established term limits. It reduced the number of cabinet posts. The 75 Constitution had a whole list of cabinet posts, most of which had never been filled. There was, most importantly, what I'll term an uneducated term, the constitutionalizing of 2 particular posts in the Cherokee Nation. The marshal, the tribal marshal, and the attorney general. When we go back in time to look at the constitutional crisis, some of the high drama that occurred was the tribunal giving instructions to the marshal service to serve warrants of seizure of documents in the principal chief's office. And of course, under the 75 Constitution, the marshal is responding and is hired and is directed and is dismissed by the executive branch. So let's see, you can't serve that warrant on me. I will simply fire you. These political wranglings were still very much in evidence among the thinking of these delegates. And so perhaps like the delegates of the Oklahoma Constitution in 1906, one of the longest constitutions in the history of the United States, we jokingly say here in Oklahoma that much legislation was embedded in the Oklahoma Constitution. They even embedded the flashpoint of kerosene. Apparently there were unwanted fires that occurred a great deal in 1906 when the Oklahoma Constitution was being written. But the Cherokee delegates wanted to see to it that the marshal, the high marshal of the Cherokee Nation, would be a constitutional post that could not be dismissed simply by principal chief, tribal council, or the court. Yes, there is a process for removal, but not simply to say you're fired. Same thing's true about the Attorney General of the Cherokee Nation as well. Those were 2 changes that were advanced in the Constitution that I would tell you were born directly out of the constitutional crisis of the mid-1990s. There was a total restructuring of the judicial article, which reestablished an upper and lower court. If you read through the 75 Constitution, there was this 3-person tribunal that technically was a court of origination and a court of appeal, which what little bit of law training I will tell you is that that's just illogical. That the only people who will look at an appellate review of a lower court's decision is in fact the very same people that made that decision. So perhaps hearkening back to a framework very similar to the 1839 Constitution, this set of delegates wanted to establish an upper and lower court. Origination, appeal. Once again, we were going to embrace a Supreme Court in the Cherokee Nation, as was diminished in 1906. That we felt was a very important return, and it speaks to the enunciation of the Cherokee Nation's sovereignty, is when a government has its own judicial system for adjudicating not only its tribal laws, but perhaps taking up the adjudication of issues with other sovereigns. This is true sovereignty. At least the delegates believe that, and I personally still believe that today. There was a total restructure of that section, upper and lower courts, as I mentioned earlier. We also looked for and identified language of the authority of suspension, sanction, discipline, or recommendation of removal as well. Prior to this Constitution being in hand, how various branches of government interacted with other branches of government was almost at plenary status. We do know from the crisis of the mid-90s that the executive branch executed impeachment proceedings against the court system itself, the tribunal. Delegates were aware of that encroachment from one branch of power to the other and sought to bring about a balance of power, returning a true balance of power to the Cherokee Nation. Not putting any of these branches outside of reach of responsibility, but setting out procedural guidelines for how that would in fact be enacted, not simply with the snap of the finger of someone saying, Cherokee Nation marshal is fired, the tribunal, the court system, you're impeached and no longer in power. Those are things that create constitutional crisis. They create an imbalance and an abuse of power, and the delegates took that up in their discussion. Perhaps most importantly was the creation of a Bill of Rights, the creation of a National Election Commission. Prior to that, there were so many things within the Cherokee Nation between 1975 and through the 90s that were either lower courts or commissions that were created by legislation. And the delegates understood the fact that if you create by legislation, you may take away by legislation. So creating a sovereignty sanctuary, if I may coin that phrase, inside of the new Constitution for those canons of our tribal government that are closest to the people, we believe was absolutely essential. And so the creation of a National Election Commission that would be independent and constitutional and therefore answerable to the people. There also was the addition of recall and removal provisions, and the reinstatement or the reintroduction of the phrase citizen. If you look in the 1975 Constitution, it talks a great deal about members of the Cherokee Nation, and we would jokingly say that people are members of Lions clubs, but we are Jalagi Ayahi, we are citizens of the Cherokee Nation, and with that comes certain rights and responsibilities. After 9 days, the document, having moved through these sections, having altered, added, in some cases totally reworked, that document was ratified, and it was done so on March the 6th of 1999. And then the work of the commission, as well as the work of the officers of the convention, because I did not adjourn the convention. I simply recessed the convention, knowing that we might have to return, might have to parlay with the federal government over these elements, because we had removed something that was very dangerous to our sovereignty is that in 1975, that Constitution actually states that any new constitutional revisions must be approved by a representative of the President of the United States. We thought it unusual that one sovereign would in fact have the authority to dictate to another sovereign its organic constitutional document. So we removed presidential approval. By the way, we wrote to the White House thinking that, well, we should ask President Clinton's opinion about this. And I still have in my archives a letter from the White House stating very plainly from White House legal counsel that the White House does not have constitutional authority to recognize or to impose upon other sovereigns. We'll hang on to that letter. We may want to remind people of that. So this requirement that was in the 75 Constitution that we're now removing from the 99 Constitution, we felt would be the removal of a great roadblock to our own self-determination. Needless to say, the federal government did not much care for that particular section. Since we were not an IRA tribe or an Oklahoma Indian Welfare Act tribe or an original and inherent sovereignty tribe, we did follow the tenets of the 75 Constitution and actually submitting these changes to the Bureau of Indian Affairs, and it became somewhat of a contentious debate. We do not have time nor inclination to go through the post years from 1999 of our interactions with the federal government. I will simply say I spent a lot of time going to Washington, D.C. and meeting with director of the BIA, with members of Congress, correspondence with the President of the United States, all of it attempting to find a clear pathway to put the Cherokee Nation on a constitutional path of self-determination. I would say, remember, I am simply a citizen of the nation. I do not speak for the Cherokee Nation. These are my private observations. The federal government was not planning to allow the Cherokee Nation to slip from their grasp of control. Just as the 5 civilized tribes were not included in the Indian Reorganization Act of 1934, scholars have told me that, well, they wouldn't want the 5 tribes to reform their governments because they were too powerful. I think that in 1999, the Bureau of Indian Affairs did not want the Cherokee Nation's constitution to be under its auspices, it being the Cherokee people. They wanted to continue to be the final word. But by the spring of 2003, we decided to move right ahead with ratification of the Constitution. Now, we had to do some interesting things. There had to be a repealer of that section in the 76 Constitution that required approval. So we had to, I thought, it's just common sense. If we can amend the Constitution, let's just remove that part that we have placed on ourselves. It wasn't federal law, it was Cherokee law that stated that we were submitting ourselves to the President of the United States. Let's just, by a vote of the electorate, let's just see if we're willing to take that out. And we did. The Cherokee people said, we're not going to ask the President of the United States anymore, which then opened the door for a ratification of the 76 Constitution. That was set for a vote on July 26th of 2003. Now, prior to that, the Commission felt that it would be imperative that Cherokee citizens understand exactly what they were voting for. I spent a lot of time thinking about how to do that. And so I created a document. This was some of my work associates helped me with it, but we actually created a flyer that compared the components of the 76 Constitution with the components of the 99 Constitution. You can't really see it here, but we sort of trucked down the middle the differentiation between the two. And we mailed this to every citizen of the Cherokee Nation. And then we held another 21 public hearings in Houston, and in Kansas, and in New Mexico, and in California, and Oregon, and across the Cherokee Nation to go and talk about this Constitution and what it means and what it says and what we have as a potential opportunity, because there were no guarantees that this would in fact be ratified. there's a great deal of intrigue that went on legally at this time. Individuals attempted to stop this ratification. They wanted to challenge how it was being voted on. The previous Constitution had talked about that any changes to the Constitution must be presented in single items, much as legislation in the Oklahoma House. We had to defend ourselves in court as a commission that, no, we are following a guideline and we're submitting the entirety. We cannot allow the ballot to say, well, you can vote on Article 1 and pass it, but Article 15 could be struck down. It was an all or nothing vote because the articles written in the Constitution were interlocking. This was not mix and match. This was not going to be Legos. You couldn't snap these pieces together. It had to be one framed document. This Constitution was ratified by the Cherokee voters in July of 2003 by a resounding vote. Now, one would think our work here is done. This is now the law of the land. We struggled with the United States government to recognize this Constitution 2003, 2004, 2005, and not until the summer of 2006 did the federal government step aside and say, that is your Constitution. We will recognize it. I would tell you in post years, even modern day elected officials have questioned the authenticity of this Constitution. Is this the real Constitution of the Cherokee people? Or is it the 75 Constitution? Or was the 1839 Constitution repealed? There are some Cherokee citizens that want to carry on dialogues of, this entire process, this chain of control, this chain of authority of constitutions are incorrect. But I will tell you that this document has been utilized and is utilized today as the organic document of our Cherokee government. I would tell you that court cases have been argued in lower courts and upper courts of the Cherokee Nation, and I would tell you that dialogue and the testimony of the 4,000 pages of the Constitutional Convention, which not only are in writing, but being modern day Cherokees, I digitized it, so it's on a CD. You can look it up if you want to. And I've placed this throughout many libraries across the country and here in the state of Oklahoma. We discovered that the 75 Constitution and certainly previous documents, but you really had to look hard to find a copy of it. Which one's the original? And where's background information? So we attempted to create a literature of this process and of this document and widely distributed so that no one would be able to challenge the authenticity or the reality of its existence. That testimony has been quoted from. The framers' intent has been discussed in court cases in the Cherokee Nation here in modern times. So I know that I'm coming close to my allocated time here with you this evening. I would sum up by simply stating that the 1999 Constitution was not just a creation of a document that moved the Cherokee Nation into a modern form of government, but it was perhaps a reconciling of the Cherokee people themselves, that there, with political opposition, with political and governmental crises, that we could come together as a common people with a common thought, not simply focusing on the needs of today, but prepare as best we can for our view of the future, to prepare a document that will lead us to the future, that will be not simply a constitution for citizens of today, but for citizens of tomorrow. This Constitution has initiative and referendum in it. It has been amended. That's for an entirely different discussion on the pathways of amendment, what has been amended in the Constitution since 1999, since 2003, since 2006. There is, just as there was in the 76 Constitution, a mandate that says once every 20 years, the Cherokee citizens should be asked, do you wish to amend edit, adjust, have a new constitutional convention. For those of you that are doing quick finger math, I will tell you that I don't know that the year is 2020. There will be much legal discussion in our courts about, well, when did this Constitution actually take effect? Was it in 2003 with the ratification by Cherokee citizens? Was it at the moment of ratification and endorsement by the convention? If that were true, then I guess we would be ramping toward 2020 as a year to relook at the Constitution. Whenever that date is, though, we do have a workable document that can be adjusted. I believe that there is a workable framework to operate off of this document. But the prospects of a constitutional convention, at least by my view, there may not be a need for such a focused activity as a constitutional convention. Citizens will decide. And that's the beauty of a tribal government that is sovereign. It's citizenry. They get to decide. I've enjoyed being here with you tonight. Dr. Coates, I would hope that you'd pass along to these individuals my contact information if you'd like to have copies or references or a bibliography of these materials that I've mentioned, whether it would be Eric Lamont from Harvard, his book on the American Indian constitutional reform. He wrote extensively on our work there. I would once again reference my articles at the law journals at Arizona State, or a number of papers at Harvard that we penned during that period of time that would be available, as well as some of these other resources.
Thank you so very, very much for being with us tonight, Jay. This was an amazing presentation. Just amazing. I thank you very much for offering your, I'm getting feedback, I'm sorry. Thank you for offering your, to share your contact information. With your permission, I'll put your email address up here on the chat so people can contact you directly with questions. And I want to ask again if anyone has questions at this time. We had one from Brandon, and I think, Jay, that you, I don't know if you saw it, but you addressed it right after it came in. So that was really fortuitous.
Maybe I did see it and thought I would just go ahead and answer that question.
So if anyone else has questions, go ahead and, okay, here's one that's coming in. Do you have a comment on the recent AG's opinion of term limits?
No, but I do have an observation, and that is it is correct for the Attorney General to render an opinion because of this election gap. As you recall, during the election of Principal Chief Bill John Baker and his contest against Chadwick Corntassel Smith, and it was embarrassing for me personally because I thought we Cherokees should know how to run elections. Someone actually called me. It may have been the Attorney General during that period of time, and he said, "I know you understand all of this, and your work with the Constitution. Do you have recommendations for us?" I said, "Yes, you should lock Cherokees who could count into a room with the ballots, and they should not come out until they have reconciled them." But that's just the banker in me speaking. Because there was a separation between our general election and so many recounts and so many contests over what the actual or who the actual winner was in that election, Principal Chief Baker was not sworn until October of that year. And so there was an Attorney General opinion that opined that in the Constitution it requires sets term limits based on term. And since the term is set out in the Constitution as beginning with their swearing in August, and since the principal chief was not able to be sworn at that time, he was not able to complete his full term, and so therefore should be eligible for a third term, because as you know, or if you would read our Constitution, we allow you to serve 2 terms, and then you must in fact sit out. You could run for another office if you wish, but the Attorney General has opined that since a term was not complete constitutionally, that therefore he would be allowed to have yet another full and complete term. I've been told that there has been a challenge to that, and that there's great possibility that there will be litigation in our courts. And that's the part that I would opine on, is the fact that the Attorney General is in the right position to issue an opinion in his interpretation of the Constitution, and Cherokee citizens or other governmental entity or individuals have a right to pursue a challenge to those interpretations in our courts. And because of the Constitution, we have courts for those questions to be taken up. That's the beauty that goes on here.
I think there's, we could also probably anticipate that somebody or other is not going to like the decision that comes out of the court. And so this may be a question that might come up at a future constitutional convention to try and clarify exactly this.
Either at a constitutional convention, or let us remind people that we have the ability for referendum and initiative in our Constitution today, just as we did in the '76 Constitution. So let's just play forward for a moment, and let's say that here's an Attorney General's opinion. Let's say that it's challenged in the courts. Individuals do not like the court's decision. The mathematical formulas are there for how initiative and referendum is to be initiated. It can be called by the citizenry. It can be called by the tribal council. So therefore, this Constitution could be amended to clarify that potential gap of understanding.
We have another question here that says, what are some of the items you wish were in the document that did not make it through the debate?
Oh, I would tell you that as chairman of a constitutional convention is much like being an air traffic controller in a combat zone. There's a lot of things moving around, and so when I would obviously had to very much be a part of the dialogue and the discussion, and there were places where I wanted to step out of the chairman's role and actually take my rightful place as a delegate and speak from the floor. But I never did that during the convention. I felt that would somehow take away the neutrality of my particular role in that discussion. Things that I would look at today, we had we did what I thought was best at the time, but there's some convolution in this districting concept. Tribal governments have challenges. I work with several other Indian tribes, many here in the state of Oklahoma, and so consequently I've become students of their constitutions. And it's fascinating to me that tribal governments will oftentimes simply try to replicate constitutional structures that they see in the state in which they are domiciled or in the federal government. And so you have to decide how you're going to frame your thinking. So are these tribal counselors, are they like House of Representatives? Or so therefore I am representing a constituency in a particular district. If we go back to the 1800s, the districts of the Cherokee Nation were not drawn by population. They were drawn as though they were states. My family are from the Ukatana, from the Going Snake district and from the Flint district. You lived in the Flint district of the Cherokee Nation. We have districts today that are somewhat, from time to time, gerrymandered by our own tribal council. I've been very keen on studying our own constitution. I live in Norman, Oklahoma. My registration as a tribal citizen is in my native Adair County, which means I won't be able to run for office back there because I don't live there, and I can't run for office back there because I live here. So I once again sort of assured my neutrality. But I have been fascinated to watch my district kind of move around. since 1999. And today it takes a unique boundary that kind of runs up Adair County and comes almost up to where my family's Indian allotment farm is, north of Chewy, there on Mosley's Prairie, and kind of makes a jump over and then starts going back down again. It almost looks like a ward district in Chicago during the 1920s. So I guess my statement would be that it could not have been conceived then, but going forward, and I understand that representation and population are critical, but there needs to be Cherokees thinking about representation at the Jalagi de Nalawi, at the council house, for our population. And we cannot, and this is a critical issue, especially for expatriated Cherokees. There are many of us that live outside of the boundaries of the Cherokee Nation. And I was actually told at one point that they felt that they were a better Cherokee than I was because I did not live back in my ancestral home. They were wrong in that thinking. Cherokees, if they study their heritage, their government, they speak their language, and they keep their tribalness, they are just as Cherokee as a Cherokee living in Dahlonega. I would press any Cherokee in Chewy to go to Sacramento, California, and tell them that somehow you are not as Cherokee as we are. That will have to be addressed in the future, most assuredly.
Again, we have another question about how many amendments have been adopted, and I think this is probably amendments to the 1999 document that we've been operating under for about 12 years now.
Yeah, and Dr. Coates, you're really in a better position to speak to that issue because I know you were serving on the tribal council when these amendments came into play. So I believe there's been two. Has there not been?
I can only think of one. What are the ones you're thinking of? Okay.
Let's focus on the one that, in fact, has carried the most weight, and that would be the freedmen. One of the elements in the Constitution that was heavily debated was on, well, who are these citizens? And if you look at the language of the 99 Constitution, it is relatively unchanged from the 75 Constitution. And I'll just paraphrase instead of going back to actually read through Article 3 in the 75 Constitution, but we talked about must be citizens as proven by reference to the Dawes Commission rules. We were also inclusive, as you recall, I mentioned early in 1867, the Lenape, the Delawares, and in 1869, June, I believe, of that year, that by treaty we adopted those particular segments of those tribes as loyal citizens of our nation. But all of it hinging on enumeration under the Dawes Commission, 1898 through 1906. You must be an original enrollee, of course, just by pure time. And the last original enrollee in my family passed away in 2006 at age 99 and a half. And so original enrollees are few and far between, or that you trace your citizenship to a lineal descendant of someone on those rolls. We did not take up a discussion of these non-Cherokee blood citizens. It was a moot point in the 76 Constitution. It was a moot point in 99. So the first major amendment, which was initiated by the Tribal Council, I might add, was to require that citizens of the Cherokee Nation be citizens by blood. That, of course, was the point of ignition for legal action by sectors of our freedmen citizenship. And of course, we had many freedmen that have Cherokee blood, but predominantly it was a concept that, well, freedmen were enumerated separately, but they were enumerated under the Dawes Commission authority, and so therefore you could extrapolate that the freedmen that were included in the freedmen rolls under the Dawes Commission, would in fact have an avenue of direct citizenship to the Cherokee Nation. Although their CDIBs under the Department of Interior would show no blood quantum whatsoever, but they would still have full rights as Cherokee citizens. And so that has been contentiously debated and litigated, and only recently has the federal courts announced that, yes, they are in fact citizens of the Cherokee Nation. All of this harkening back to an article of the Treaty of 1866. And you look at all of these documents, whether they be treaties or constitutions, we are all prisoners of our time. And since the Cherokee Nation took up arms against the United States, as well as supplied arms to the United States, and I speak of arms as in troops, not weaponry, during the American Civil War, the United States decided that they would punitively attack the Cherokee Nation by looking as though it had, in its totality, taken arms against the United States. So therefore, the punitive incursions into the Cherokee Nation that are brought out in the Articles of the Treaty of 1866 included required right-of-ways for railroads across Indian country, the harbinger beginning process of creating the settlement by land in severalty, evaporating the corporate holdings of land by the Cherokee Nation and moving it to individual allotments. I think that it's well documented by historians and legal scholars that the diminishment of tribal lands held in corporate, moving to an allotment process, was yet another strategy of the federal government attempting to diminish the tribal power of the Cherokee Nation. Once again, they underestimated our ability to remain. So all of those items leading toward a very contentious debate, and I think even though the federal courts have opined, it will still rage on for a while about, well, are these Cherokees that are without Cherokee blood true citizens of the nation? Legally and by federal court and by interpretation of the Dawes Commission, the answer is yes. How that will be addressed in future years, we'll have to wait and see. Because one could then come to the question, well, what of the Delawares? What of the Shawnees? And I have one great-grandfather who was an intermarried white. My name is Hannah. It's a good Scottish name. It's much like Adair and Ward and Thompson. But John Watson Hannah was an intermarried white among the Cherokee Nation. We need to remember our last tribal, Golwoniski, the last speaker of the tribal council, was a non-blooded Cherokee. So in many ways, we have a very historical background for simply adopting and accepting and being highly inclusive of people that come to live among us, if they will come among us to live as us. At the same time, there are arguments on the other side, because since the allotment era, this whole concept of blood quantum, which is not a Cherokee concept, is a concept of the federal government. I think that if we could get on our way back machines and talk to my great grandmother, Julie Still of the Tikananiskis, and we were to ask her of her blood quantum, she might be able to do the mathematics to say, well, I'm a quarter Cherokee, but she would look at it and say, I'm a Cherokee citizen. No matter what color I am, no matter what blood quantum I am living as a citizen of the Cherokee Nation. So that's the primary amendment. Julie, I'm perhaps flawed in another amendment that perhaps was talked about but didn't make its way to action, and that was over, I want to say, the residency of the principal chief. There were some other discussions on districting that also came up. But we do know that the first and perhaps the most contentious amendment to the 1999 Constitution was that surrounding the concept of blooded Cherokees as citizens.
Okay, well, I would like to say, Jay, that your leadership at that convention was just mind-blowingly good. And I have always thought that could have been just a real mess in the hands of someone less skilled. I appreciate it. I know everyone there appreciated greatly your neutrality, your leadership, just your humor, because that's what really, I think, sort of set the tone for the civility that all of us experienced as part of that. And I said to you earlier today when we were talking, it wasn't just while we were in the meeting, it continued after we left the meeting and after we went out to dinner together and after we went home and after we, continued to talk with each other informally in the days afterwards. So it was, I just thank you so much for your leadership there and for being with us tonight as well. And if you don't mind, I will share with you, because I asked you, you may have forgotten, a couple of years ago about the perhaps convention that may be coming up in 2019 or 2020 or at some point in the future. And I asked if you would be willing to facilitate that again. And you may recall that you told me you were going to be doing laundry that day.
I think I'm going to be out of town that day. I don't know that I'm going to be doing laundry, but I may be rearranging my stamp collection. I may need to dethatch my yard. I may need to go home to Ada County and find a comfortable seat and watch a younger contingency of Cherokee citizens that will take their metaphorical stepladder and climb as tall upon it as they can to look over the curvature of time to the future of the Cherokee Nation. Because that one factor is the real proof of our existence, is that we have a future, that we are sculpting our future, and that our voices of today will have resonance across time. In our language, I would say, uli halaiste. It's been my great honor to be here with you this evening to speak about the Jalagi Gagustadi of the Constitution. It is our written document. It is the foundation that causes us to be a government. It causes us to be a people that is united together in living together in peace and under the rule of law, not always agreeing at the council house, but ultimately reaching a consensus to grasp our self-determination and for us to exist as a known and identifiable people. And for this, I believe that when it comes my time to walk on and to cross the river, that my Jalagi Alisis, my Cherokee grandmothers, hopefully they will not snatch me bald and say, why didn't you do more? I'm hoping that they'll say, come on in and have a seat. We've been waiting for you. Well done, Oganale. Thank you, my friend, for allowing me to be here this evening.
Thank you, Jay. Perfect words to end on. I would ask everyone to stay for just a moment. We have some announcements that Kimberly will make.
Well, thank you for everyone joining us tonight. Special wado to Mr. Jay Hanna and, of course, Dr. Julia Coates. Our next webinar is on April 26th, The Continuing Impacts of the 1999 Constitution on the Cherokee Nation. To learn more about the Cherokee Pens Project Foundation or to get involved, please contact us at www.cherokeepens.org or email us at cherokeepens@gmail.com. Donaga Gohanyi.